And good morning. My name is Alan Nochumson of Nochumson P.C. I was actually talking to Dan. I was asking him how long I've been teaching at Jenkins, and it's been a while. So I looked at my materials. I've been teaching this course since 2011. And a little bit about me, I have my own real estate firm in Philadelphia, and one of my primary practice areas is landlord tenant law. One of the things that kind of differentiates me from other attorneys in the Philadelphia region is that I've been writing a real estate column for the Legal Intelligencer for the better part of my 20-year career. So as Dan stated, you can go on my website and you can look at my articles. So I write this monthly real estate column. I would say probably a third of my articles are actually within the realm of landlord tenant law. So there's a lot of information out there. And as Dan also stated, I welcome questions. I try to treat this as an interactive learning exercise and discussion. So feel free at any time to pipe in verbally, which is probably easier, or you can, I guess, comment and Dan can ask the question on your behalf. So besides what's going on here in terms of the landlord tenant law, which we generally teach, we're in COVID-19, and COVID-19, there's some special considerations to consider. And, you should go to our website too. We created a COVID-19 resource center with regards to that, which deals a lot with landlord tenant law. Governor Wolf recently issued an executive order staying all new landlord tenant matters in the Commonwealth of Pennsylvania through July 10th. And what does that mean? If you sent a notice of default to vacate or termination, that stayed until July 10th, like the time frames in which the time periods would start accruing. And then on July 10th, then it would start anew, whatever the time frames are. So, and we'll talk about what the time frames are under the Landlord Tenant Act of 1951. So both for commercial and residential matters, landlords are not going to be able to evict their tenants based on a notice of default, because that notice of default is stayed and not effective until the start of July 10th at the earliest, unless there's another executive order. As far as and you're not going to be able to file any new eviction matters based on that as well. As far as any pending matters, right now, the court in the municipal court in Philadelphia, that's where landlord tenant matters are. The municipal court has postponed all hearings through May 29th. So if you have a hearing on a pending eviction matter, through May 29th, you're not going to be heard. Afterwards, we'll see, but I'm assuming they're going to also extend that out further. But we're only May 15th, so we'll see what happens in a couple of weeks. As far as if you had judgments, for possession against a tenant or a landlord did, that stayed through the month of May. But right now, if you have a pending judgment for possession, you can execute it starting June 1st. So again, we'll talk about the whole execution process and the eviction process of having a landlord tenant officer involved. But right now in the municipal court, you can evict, but only starting June 1st. So that's where we are in terms of COVID-19. So as Dan stated, I apologize. Like, he gave you just it's before this CLE, he gave you the materials of like articles that I've done over the past. I don't know how up to date it is. Dan asked me last week to do this CLE, and I said, of course I would. But this is just an example of some articles we've done. Again, go on my website, nochumson.com, and you'll see a lot more articles about landlord tenant law and other areas of the law as it relates to real estate. But I did provide Dan before the meeting. Excuse me. Let me see. Hold on, I'm trying to get in here myself. Okay, hold on. Just apologize. I'm trying to work through this. I got disconnected from my own computer. There's a body of materials where I wrote about like landlord tenant law and how to basically evict someone in Philadelphia County. I'm trying to get back into my computer remotely at work. But while I do, the first thing that you really need to focus on if you're representing a landlord is to make sure that the landlord is properly set up, right? And what do I mean by that, right? There are certain requirements that a landlord must actually follow in order to be able to evict a tenant in Philadelphia County. So the first thing is they have to register as a landlord in Philadelphia County. And how do they do that? Well, the first thing is they got to make sure that they have, whether it's a corporate entity or an individual, they have to make sure that they have what's it called, a tax ID number with the city of Philadelphia. And this is something that you can get online to actually get a tax ID number with the city of Philadelphia, stating that basically you have an investment or business in the city of Philadelphia. Here, you're a landlord. The next thing that you would have to get is what's called a commercial activity license. And again, that used to be called a business privilege license, but it sounds better that, as compared to you have the privilege of doing business in the city of Philadelphia, it's a commercial activity license instead. That's a one-time fee. I believe that fee is $250. They may have raised it to $300, I think, recently, but we don't really get in the weeds that much. But so first thing is they have to get a tax ID number. Secondly, your landlord has to get a commercial activity license. And then what they need to do is every single year, your landlords need to get what's called a housing inspection license. And people know that better as a rental license. And you apply for it. And again, if you go on my website, I actually think I have a link to that in one of my legal alerts. But a landlord every single year is required to have a housing inspection license for each unit that they're renting out. So if they have like 10 properties, each single family, they need to get a housing inspection license as to each of those properties. And again, you can apply online for the housing inspection license, and you can also renew them online as well. And the reason why that's important to get a housing inspection license is because God forbid your landlord has to evict a tenant. You're not going to be able to evict them if you don't have a housing inspection license. And we'll talk a little bit about that when we talk about defenses a tenant can have. The other thing that a landlord needs to focus on, in addition to the housing inspection license, is anytime they start a lease arrangement, and this only applies to residential tenants, by the way, the housing inspection license and the certificate of rental suitability. But anytime the landlord starts a landlord-tenant relationship with a tenant or extends the lease out to that tenant in a residential context, the landlord has to provide the tenant with what's called a certificate of rental suitability. Again, if you go on my website, you'll see believe there's a legal alert with a link to it, but it's basically, unlike the housing inspection license, which I believe you have to pay $50 per unit, residential unit each year, the certificate of rental suitability, there's no fee associated with that, right? So you just go online, you say that who you are, what the property is, and they'll automatically generate a certificate of rental suitability saying the property is suitable for rental purposes, assuming, first of all, you have an active housing inspection license, and then secondly, that there are no violations against the property. And it's important to have the certificate of rental suitability and give it to the tenant and you're required under law to give it within 60 days from the date the lease tenancy starts. It's important to have that and to give it to the tenant, because later on, one of the things that you'll see, and I'm sure if anyone here has practiced landlord tenant law will see, is that one of the ways that tenants try to defend themselves from an eviction is to start complaining about the condition of the property. Sometimes it's legitimate, sometimes it's just more of gamesmanship. And when they complain about the condition of the property, one of their go-tos is to actually go to L&I, licenses and inspections, and to file a complaint, right? And once L&I is involved, very likely it happens where L&I will find some violation against the property. And if there's a violation against the property, and the landlord did not get the certificate of rental suitability, they're not going to be able to get their certificate of rental suitability until the actual violations are removed. So it's really important to get the certificate of rental suitability at the beginning of the lease tenancy, because you don't want to have a situation where you're fighting to get the certificate. Because again, as we'll talk about it, when we're filing the complaint, that's one of the prerequisites to filing the complaint. They want to see that you received the certificate of rental suitability from L&I, and you have to show proof that you actually gave the certificate to the tenant. So in addition, when you're starting a lease tenancy, right, the other thing to focus on, in addition to the certificate of rental suitability, there is an associated Partners for Good Housing handbook that L&I that has on site, online as well. Again, if you go to my firm's website, I believe there's a legal alert about a link to the Partners for Good Housing handbook. So again, just to focus you, when you're signing a lease or there's an extension of a lease term, there has to be a delivery of the certificate of rental suitability to the tenant, as well as the Partners for Good Housing handbook, and you have to show proof of that. So as a practice matter, one of the things I tell my clients to do is that the lease should have a provision in it where the tenant can acknowledge that they received the certificate of rental suitability and the Partners for Good Housing handbook. That's one of the ways to show proof, if eviction takes place, that they received it, right? So maybe there'll be a check mark that, where the tenant acknowledges they received the certificate of rental suitability and the Partners for Good Housing handbook. Another practice point that I tell a lot of my clients, and I've told, attendees of this class, is that once we have a fully executed lease agreement, I would highly recommend that fully executed lease agreement be saved via like a PDF, as well as in attaching the certificate of rental suitability and the Partners for Good Housing handbook. And I would give that via email or some electronic form to the tenant, so you have an email showing that you sent them something. Like, you can't show proof of what was in the PDF, but you would state, here's a copy of fully executed residential lease agreement, the certificate of rental suitability that I gave you, as well as the Partners for Good Housing handbook. So from a practice point of view, that's what I would focus on, right? And then in terms of the condition of the property, there's always an issue.
Alan?
Yeah.
Can I ask the question? I think you said you went over this, but I might have missed it. Does the certificate of rental suitability have to be gotten for each new tenant every time that you re-rent the property, or is it something that you get in the beginning and then just pass on from tenant to tenant?
That's a good question. So it's tenant specific. While the housing inspection license is specific to that actual unit. So say I have a house, right? 123 Main Street, and I rent it to you today. And for whatever reason, you leave 6 months from now, and I still have that license, that housing inspection license. And then I lease that same property to Mr. Smith. I don't have to get a different housing inspection license for you versus Mr. Smith. It's just a license to rent the property for a certain time period. That differs from the certificate of rental suitability. That's specific to a particular tenant. So if I rent it to you today, there's a safe harbor provision of 60 days. I have 60 days from the date that I rented the place to you, that you signed the lease, to provide you with the certificate of rental suitability and the Partners for Good Housing handbook. After that, if you look at the Philadelphia Code, I can't get possession of the property until I show you proof, or the court proof, that I gave you that certificate of rental suitability, and I can't get rent from you during the period of time in which you didn't have the certificate of rentals. You didn't have the certificate of rental suitability and Partners for Good Housing handbook. So just say you rented today, and I didn't, and let's just say 60 days later, we're 60 days fast forward. You never received the certificate of rental suitability from me, and you never received the Partners for Good Housing handbook. Say like a month later, you didn't pay your rent, right? I want to sue you for that unpaid rent. Well, the court right now, and we'll talk about it, will actually, the judge announces at the time of like before any of the hearings, stating that if your landlord did not provide you a certificate of rental suitability or a Partners for Good Housing handbook during a time period in which you didn't pay rent, you don't owe it. They actually give a letter to all the tenants as soon as they come in. Any landlord who's quote unquote non-compliant with that requirement, the landlord, the court will give, the court officer will give the tenant a letter saying, you know, in a long way, hey, you lucked out, your landlord screwed up. I'm not going to give the landlord can argue that you didn't pay the rent, but because you didn't give the certificate, which by the way is a self-serving document, and the Partners for Good Housing handbook, it's just it's like a 20-page document saying, hey, you have a landlord, they're required to keep the property up and yada, yada, yada. But if the landlord didn't give those documents during the time period in which you as a tenant were in default, you're not deemed in default. So it's a very impactful document. And I don't see as many landlords get tripped up by that as much because they've learned their lessons. But if you have a newbie landlord, it's something to really focus on. And it's one that when you get hired as an eviction attorney, that's one of the documents you're going to ask for, which you're going to need to include in your electronic filing in Philadelphia County. If it's residential, you're going to need to have the commercial activity license. You're going to need to have the housing inspection license. You're going to need to have the certificate of rental suitability and the Partners for Good Housing handbook. In the complaint itself that you fill out online, it actually asks you for those documents, and then it states, what's the date of the housing inspection license? What's the date of the certificate of rental suitability that you gave them? Because when you get the certificate of rental suitability, it's just a form saying this is certificate of rental suitability and it's suitable for housing purposes. The landlord actually has to sign and date that, right? So again, you have to have your landlord have a copy that's signed and dated, and then show proof that they gave it to the tenant. But like in the complaint itself, it states, when did you deliver this to the tenant? So if you don't, you can file the complaint even if you don't have a certificate of rental suitability or a housing inspection license, but it'll be flagged, by the court. So when you have the day of the hearing, the tenant's going to be on notice that that the landlord can't collect rent during that period of time. Did I answer the question?
Yes.
Okay. Does anyone else have questions?
Actually, what I got to do, this is Dan, I got to jump in and give him the first participation code. So the first participation code is disputes, and that's plural, but I'm not going to get crazy about it. Disputes. One more time, it's the word disputes. You're going to send me this one, plus the other three, plus the evaluation scores, and your PA attorney number after class to classes@jenkinslaw.org. That's the last time I'm going to mention all that, but the first participation code is disputes. Okay, back to you, Alan.
All right, thanks, Dan. Anyone else have any questions? Okay.
Yeah,
So
Alan.
another thing that I see in terms of when you have this, yeah, oh, sorry.
Yeah, sorry, I have a question.
Sure.
How often do you have to do the inspection in order to get the certificate? Is that an annual thing or is that per tenant?
It's per tenant. So it's funny. It's called this. The housing inspection license is yearly.
Sure.
So it's for a year period. So you have to renew that every single year. Now, if you're not compliant with the city, if you owe real estate taxes or personal income taxes, or there's violations against the property, you're not going to be able to get either the housing inspection license or the certificate of rental suitability. So the city has made it really difficult for landlords to be able to conduct business. There may be a violation against the property through no fault of their own, just because they're being bothered by a tenant. And again, if I live in the city of Philadelphia. If L&I came into my house, I'm sure that they can find something wrong with my property. Is there something wrong? I don't know, but I find from anytime a tenant calls about a situation, they will always find something. So the housing inspection license is a yearly thing. The certificate of rental suitability, if you go online right now and you own a property and you want to rent it out, assuming you have a housing inspection license, you could get a certificate today, tomorrow, the next day, how many times you need it, depending on how many tenants you need it for. So did I answer your question?
Yeah, so basically the certificate is basically proof that all these conditions have been met.
Yeah, and there are really no conditions. Again, the certificate of rental suitability, all it's saying is that you have a housing inspection license, there's no violations against the property of public record, and quite honestly, you don't owe the city any money. So like that's basically it. And then you would give it to your tenant.
So,
Got it. Thanks.
You're welcome. Any other questions?
yeah, Ellen, John Walker, I have a question. If you have a tenant that you've had for 8 or 10 years in the premises before these rules went into place, at some point, are you obligated to bring them into compliance with the current rules, or do you have to do this?
That's a good question. And, you know, I'll be honest, I haven't looked at that issue in a while. I know that the certificate of rental, it's on the complaint too. It asks you if this tenant's been in the property starting a certain date. So I would think, and I'm not 100% sure, if your tenant was in pre-certificate of rental suitability requirements, technically they probably wouldn't need a certificate of rental suitability, but I wouldn't bank on that either. I haven't honestly researched that issue. I would recommend every time that they renew their lease, I mean, and most landlords don't do that, but anytime the lease is renewed, the term, to provide them with a new certificate of rental suitability and Partners for Good Housing Handbook, and show some type of proof that they received it. It's not just giving it to them. I've gotten dinged from judges where my client can't show that they actually delivered it to them. You know, they're like, oh, I hand delivered it to them. And then the tenant's like, I have no idea what you're talking about. I never received this document. And some of the tenants may be honest. They received so many documents over a course of a year from maybe the landlord. They may not, it depends on the sophistication level of the tenant. They may just not pay attention to the fact that they got something. So I find it important for the landlord to give the certificate of rental suitability and the Partners for Good Housing Handbook in a way that you can show the court. So I find that email is the best way to do that, right? And it's for your records anyway. So did I answer your question? All right.
Yeah, that's cool.
Cool.
Yeah.
So the other thing that I find, the other issue besides like, you know, being able to collect rent is the other issue of like the condition of the property. You know, a year, like I rent a person to my property to Mr. Smith. A year from now, Mr. Smith moves out, and all of a sudden there's a fight about the condition of property, saying, oh, the hardwood floors are scratched up, the carpet stained, something happened where I, as the landlord, have a grievance with the tenant, and I want to use a portion of that security deposit to cover those things that go beyond wear and tear. So how is one to prove that the tenant actually caused the issue? And by the way, from the tenant's point of view, how can the tenant prove that they didn't cause the issue? So one of the things I do is, and I've created a lease agreement package. In addition to the lease, I have a checklist. Like we've all gone to college. Most of us, I assume, like went away for college where you were in a dormitory. You know, I don't even remember, you know, when you walked into that dormitory, you did, like I was an RA, so we had a checklist, right? We had, you know, where the student would sign off about the condition of the property. I would do the same thing if I'm a good landlord, right? And I have nothing to hide and I want to do the right thing. And I don't want people to pay for things that a tenant shouldn't have to pay for. But I want if I'm a landlord and the tenant does something bad, I want them to pay for it. I would have like some type of checklist where we would walk through and say, okay, we're good or we're not, and have both parties sign it. I would also recommend that as the landlord and as a tenant to take as many pictures from as many angles as possible. And then again, how can you prove, what the condition was about the checklist, that someone received it, that someone signed it, because things get lost in the shuffle because we're all busy. Again, as part of the lease package, you would say, here's this fully executed lease. Here's the certificate of rental suitability and the Partners for Good Housing Handbook. And here's the checklist that both parties signed along with corresponding pictures. So here's a snapshot that both parties can save somewhere in the cloud or on their computer. So God forbid a year from now or less or more, there's an issue. we're all on the same page. We all have the same starting point. So that's one of the things that I recommend. So does anyone
Okay, Alan, we had a chat question. It may actually be more of a comment even, from someone who said, I like to attach the certificate of rental and first page of the handbook to the lease, along with a special clause that they received it. So it's more of a statement, but I'm going to read that for you and you can say what you want about that.
I would agree with that. So I stated the same thing. If you don't want to send it as an email, like proof that they received it, it's a PDF document, the handbook, right? So again, you can go online, you can save it. Another practice point, if you really are like someone who's not technologically savvy, like a landlord, again, the practice point I have, whenever I have someone sign a lease agreement or documents that are really important, I make sure that the signature page obviously are signed and dated, but then each page of the document is initialed by the parties, right? And then you can save that document. I prefer digitally, but if you don't have it digitally, like you can save it, in terms of copying it and keeping it somewhere safe. So again, if you have to go into landlord tenant court and the judge is like, well, show me proof that the tenant received a certificate of rental suitability in the Partners for Good Housing handbook. You show the judge, hey, here's the certificate of rental suitability, which by the way, doesn't have a part of the certificate, which makes no sense for the tenant to sign. But here I had them initial and or sign and date it. And then here's the Partners for Good Housing handbook. And every single page is initialed and or signed by the tenant. So that's a way to protect yourself. So does anyone else have any questions? Okay, so the next thing that I focus on in this lecture, and you'll see in the materials that Dan will send you afterwards, base level, right? We got a fully executed lease. Hopefully the landlord sets himself or herself up by getting a housing inspection license and delivered a certificate of rental suitability, Partners for Good Housing handbook. Hopefully the parties took pictures and did a checklist. Okay, well now we're in the lease, right? And now we have a situation where the landlord doesn't believe the tenant's following the lease for whatever reason, right? So what are the grounds for eviction? Well, first of all, if it's for rent, right, that's a simple one. A lot of times though, it could be a breach of the condition of the lease, right? So not all breaches are material, right? So maybe you have a no dog policy. Maybe you have the tenant can be the only one that lives there. And if there's anyone else that lives there, they would need landlord's permission. So there's a ton of conditions that the tenant needs to abide by, right? So those are things to focus on when you're thinking about eviction. Why are you evicting them? Are you evicting them because they didn't pay their rent or utilities or things like that? Or is it because they breached the condition, right? So first things first, if you're the landlord and you believe there's grounds for eviction, look at the lease, right? So the lease actually, under the Landlord Tenant Act of 1951, and that's what the landlord and the tenant have to follow in Pennsylvania, it allows actually for the parties to waive like certain notice requirements. So typically, if the landlord wants to send a default notice or a notice to quit to the tenant for a breach, the parties can agree that the notice requirements are waived, right? So for rent, if rent isn't paid, there's a 10-day notice requirement under the Landlord Tenant Act of 1951. So if I'm the landlord and the tenant hasn't paid, I send a notice to quit, right? And say that the tenant has 10 days to leave, right? If it's because of a breach of a condition that we believe is material, right? If the lease is for less than a year, you have to give 15 days notice. And if it's more than a year, you have to give 30-day notice. Now, one of the things that ties up some landlords who don't hire an attorney, they make the notice to quit conditional, right? So especially when it's dealing with money. So if the landlord is owed money, they'll say, well, you owe us money, and if you don't pay us within this 10-day period of time, you need to leave. Well, that's not an effective notice to quit, because the notice to quit provides the jurisdictional grounds to actually file the complaint, right? The eviction complaint. And if you give a conditional notice to quit, that is not effective, and your case could be thrown out on those grounds alone, right? Now, how should the notice to quit be sent, right? Your lease will say what the proper notice requirement, your lease should say what the proper notice requirements are. Is it first class mail? Is it certified mail? Is it email? Is it fax? Is it, even text message? It gets more complicated or more comprehensive when you're dealing with a commercial lease context. But from the residential lease context, sometimes, you have mom and pop leases that were downloaded from the internet, which may or may not be comprehensive. So if you have one of those and there's no mention of how notices or any written or communications are sent between the parties, I would recommend, to send things certified mail, first class mail, maybe with a certificate of mailing. So then you actually state to the court, or if you have to go to court, that something was mailed. They don't know what was mailed. Same thing with certificate, a certified mail, but do a certificate of mailing. I'm a big believer, again, I keep saying over and over again about electronic transmissions. So email, I would email the document, because you want the tenant to actually have no excuse that they didn't receive it. Because when you send things certified mail, they can ignore it and not take that certified mail, because no one wants a green card, right? Whenever you have the post office worker come by your office, with something that's certified mail, or in your personal life, it's never good. So you may not sign for it. That's why I do the certificate of mailing for first class mail, because at least it's going to get there. But how do you prove you actually mailed it, other than doing a certificate of mailing with the post office? But that's why I send things via email. And then I also, in my documents, as a practice point for my leases, state that the parties can communicate via text message, and you'll have the cell phone numbers of the various parties. You can take that as a picture, the notice to quit, and show that you actually sent that as well, the notice to quit. So those are the things that tie people up, is that there's a conditional notice to quit, and then you don't have jurisdiction to file the complaint, and then to actually be able to prove that you sent the notice to quit, right? So those are things to focus on. And then, in terms of the grounds for the notice to quit, the notice requirements can be completely waived, but if they aren't, for rent, it's 10 days notice. And for a condition, it's 15 days for a lease less than a year, or lease term less than a year, and 30 days for a lease term more than a year. The question is whether the condition that's allegedly been breached is material. So,
Alan, let me jump in. I'm sorry. I have to jump in with the second participation code, which works out perfectly because I came up with this yesterday. The second code is notice. Second code is notice. One more time. Second code is notice. Okay, back to you.
Okay, great. The other thing that ties people up, because a lot of people use these mom and pop leases, you got to make sure that your lease has a demand for rent, because technically if your lease doesn't have a waiver requirement for that demand for rent. So every lease should say the landlord doesn't have to state every single time the tenant owes money that they owe money. The tenant actually waives that demand for rent requirement. If the lease doesn't include that waiver, then the tenant can technically say no rent is due. So that's just a practice point. So, all right. So these are some of the things to focus on, pre-litigation. Now we're going to file a complaint in Philadelphia County. And I'm hoping that most of you have, in one way or another, done that over the course of your career, so you'll know what I am talking about. But the municipal court, you can file it electronically or in person. If you're an attorney, you're going to file it electronically, because I think if you file it in person, it's going to cost you extra money. It's more of a hassle. But just for your own information, the landlord tenant court in Philadelphia is at 1339 Chestnut Street. The courts are on the 6th floor, and the administrative offices are on the 10th floor. And just as a matter of background, the landlord tenant officer, because the sheriff doesn't effectuate evictions at the municipal court level. So at the municipal court level, if you file something, The landlord tenant officer is the one that effectuates the evictions. Their office is at 123 South Broad Street, 16th floor, which is actually happens to be the same floor that my office is in. I was there before them. They moved. They were like on 12th or 11th Street for the longest period of time. For the last few years, they have been in my building on my floor. So if you need to deal with them, like the landlord tenant officer, some of the filings have to be hand delivered. That's where you would go, right? So you're thinking about filing complaints, right? We're talking about municipal court where they are. You have a choice between filing complaints in municipal court or the Court of Common Pleas. Why would you file in municipal court? Well, municipal court is kind of like the people's court, right? So it's informal and it cuts both ways, but if you're a mom and pop landlord, you can represent yourself, right? And actually in the municipal court, they have a form called an authorized representative, someone who's not an attorney and is not the landlord. Like if we're talking about a personal landlord, like say Mr. Smith owns the property. Say Mr. Lee, who's his friend, wants to represent him. Technically, even though I would consider that the unauthorized practice of law, Mr. Lee can represent Mr. Smith in municipal court. You just got to sign an authorized representative form. A lot of times you'll see management companies representing their clients in the municipal court, right? So it's more informal. So if someone doesn't have an attorney, it's more informal, and which allows like the landlord to actually try to evict someone. While if it was Court of Common Pleas, people would get kind of tied up with the process and you have to file a real complaint and things like that, where the landlord may not want to actually have to deal with that. But another reason, more important reason to file in the Philadelphia Municipal Court, which has the landlord tenant court within it, is the fact that the hearing takes place usually 4 to 6 weeks from the time of the filing of the complaint. While if you file the complaint in the Court of Common Pleas, again, even expedited would be 8 months, right? And then you would have a whole process with discovery and things like that, where, again, time is money. So to have a hearing within 4 to 6 weeks versus potentially 8 months or more is really the reason why the landlord actually prefers the Philadelphia Municipal Court, right? So when you're filing complaints, and you're filing it online with the municipal court as attorneys, right? The things that I stated that you're going to need: copy of the fully executed lease, the housing inspection license, in effect, as to that unit, the certificate of rental suitability, that the certificate of rental suitability that you gave, or the landlord gave the tenant, and proof, and you should make sure you have proof of that. You don't need that for the time of the filing the complaint. You'll have to have the Partners for Good Housing Handbook. That does not have to be included technically, as part of the filing. I do include that as an exhibit, and I do include proof that I gave the certificate of rental suitability as an exhibit. Then they ask you other questions. Are there any notices of violations that you know as to the property? It's going to come out either way, so might as well be honest. If there is a violation against a property that's of record issued by L&I, the other thing that they ask for: are there any people that live in that unit ages 6 and under? The reason is under the lead-based paint law, if there are people who are under the age of 6 and who live in a property that was built before 1978, then there are certain requirements or disclosure requirements the landlord needs to give. And if they didn't give it, again, we're talking about no rent is owed for the time period that you didn't have a housing inspection license. No rent is owed for the time period in which the tenant didn't have the certificate of rental suitability in the house and the Partner for Good Housing Handbook. No rent would be owed under the law if there was a lead-based paint certification requirement for that particular property and the tenant did not receive that and the landlord did not get it. So again, there's a lot of traps here when you're representing a landlord in Philadelphia County. There's a lot of requirements. So the court asks, do people who are under the age of 6 live there? And did you get a lead-based paint certificate? Now, I know the law has changed recently, and again, if you go on my website, I did write an article about that. I think they expanded the requirement about a lead-based paint certificate, and it's going to be rolling out over the next few years. But there is a certificate that's going to be required for all these properties that were built before 1978. So that's something to look at as well. So you're going to be asked about, like, in addition to the complaint, you're going to have to provide your commercial activity license. You're going to have to provide your notice to quit, showing proof that you mailed. Like, I always include proof that I mailed it. And then it's pretty simple. Like, what are your grounds for eviction? So does the tenant owe rent? Great. Well, tell me how much they owe. Tell me if there are any late fees. There's a part where you can put a thing for attorney's fees if attorney's fees are owed. Again, I usually state, like, in the body of my description or the note section, if I'm asking for late fees, attorney's fees, interest, I usually tell the court clerk the provisions of the lease that allow me to get those amounts, at least under the lease. Because I'll tell you, the clerk that reviews the complaint will bounce it back for many different reasons, including the fact if they can't see why you're asking for something under the lease. You would think the judge would have to, like, look at that, but the clerk actually they're pretty strict, the clerk in the Philadelphia Municipal Court. So, and the other grounds for eviction, you would have a breach of the condition, or maybe they termed out, right? So we didn't talk about this. You tell the tenant, hey, we're done. The lease ended, say the lease ended today and you didn't leave. I want you out of here, right? So you have to give a notice to quit, saying that, you breached, the condition of the lease by not leaving, whether you give 15 days notice or 30 days notice. And that would be one of the grounds. So there are 3 grounds when you are evicting someone: non-payment of rent, breach of a condition, or out of term. The reason why I would focus, if I'm a landlord attorney, on the breach of a condition or out of term, those are things that can't be technically cured. When rent is not paid, that can be cured, and technically under the law in Pennsylvania, the tenant can stay, right? So Pennsylvania is a pay-to-stay state. So if the tenant owes money and there's a judgment that's eventually against that tenant, say for like $3,000, if the tenant pays that money before the locks are changed by the landlord tenant officer and they cure technically that default, they get to stay. You can't cure the fact that the lease term expired, right? You can't cure that there's a material breach of a condition, right? So as a landlord's attorney, I always try to find, and obviously not find, but make sure that if there are conditions that are breached or we're out of term, that's part of the complaint. Because if you don't want the tenant there anymore, those are the ways to make sure that doesn't happen. Because some tenants will not pay until they really have to pay, right? And that could be just before the landlord tenant officer changes the locks. Now, with that being said, last year, the city of Philadelphia instituted a bill, or passed a bill called the Good Cause Eviction Bill, and that's on my website as well. So if a landlord wants to evict a tenant, and this only applies to month-to-month tenancies, but if a landlord wants to evict a tenant, they have to give a special notice under this Good Cause bill as to what's the good cause to evict a tenant. If they owe rent, you got to state that. But there's certain ways that you have to draft the notice to quit, and you have to give the tenant certain abilities to either cure it or deal with the situation. So I would, again, I know we're running out of time and this can be a lecture that's a few hours, but I would ask you that you read that article that I wrote, where you would make sure that you've complied with the Good Cause Eviction Bill that was recently passed by the city. Are there any other questions?
Well, Alan, let me jump in with the third code. Third code is Philadelphia. Third code is Philadelphia. One more time, Philadelphia. Okay, over to you.
All right, cool. Dan, how much more time do we have?
You have basically 9 minutes.
Okay, cool. Cool. That should be enough time to talk about the rest of things. All right. So we filed the complaint, right? We're going to get a hearing date because you're asked if there's actually a bring down where you get a hearing date for the actual eviction hearing. Now, the tenant obviously has a right to file a counterclaim. If they want to file a counterclaim, they have to do it 10 days before the hearing with the court. Either side can ask for a continuance. That continuance has to be of the hearing, has to be put in writing with the court at least 10 days before the hearing. If that's the case, it's almost an automatic continuance, especially on the first listing, right? If the continuance request is made within that 10-day period of the hearing, like less than 10 days, then the parties have to show up because there's no guarantee that the court will grant that continuance because they'll do it on the spot, right? So you come to court that day as the landlord, as the tenant, you're in a big room. I think it's hearing room 3 on the 6th floor. And what happens is the commissioner comes out, right? Reads the list of the matters. They go first with the matters that the landlord is represented by counsel. So if I'm the attorney and I have multiple matters, they'll read all my matters, see if the tenant's there, and if the tenant's not there, we can have, like in most cases, a default put in, and then the commissioner will also, before actually even calling a list, will, like I said, give that piece of paper for landlords who are flagged as non-compliant with not having a housing inspection license, a certificate of rental suitability, or the Partners for Good Housing Handbook. Tenants will receive that letter before the list is called. Then say, I'm there, I have a matter, the tenant comes up, their name is called. The commissioner will state, well, you have an opportunity to try to work it out. We can work it out, between us, or we can try to have a mediator work with you. There's also a lawyer for the day now. So lawyers will be, it's income sensitive requirements, but a lawyer will be there that represents tenants. And I believe actually there may be a program now with actually tenant paid attorneys. But we can try to work it out, or we can go in front of the judge. So sometimes what we enter into, we always try to work it out before we go in front of the judge. And what we can enter into is what's called a judgment by agreement. And again, it's an online form, but the parties can agree that, the tenant will pay a certain amount of money as a judgment, and then they'll pay under certain arrangements. Sometimes as a tool that I have is that I'll say, here's a judgment for money for X amount. If you pay this or even a lesser amount, I'll satisfy the judgment. But in order to have leverage too, I'll say, you have to pay this amount. I have a judgment for possession that you agreed I have for that date of the hearing. And if you miss any of these payments that are required under the judgment by agreement, I can evict you. Now, if the person's unrepresented by counsel, the court actually has someone who reviews the judgment, assuming we get into a judgment by agreement. The court actually has someone who reviews the judgment by agreement with the tenant, right? So, and then once they feel confident the tenant understands the ramifications of this judgment by agreement, then the parties can sign it. So one of the good things as a landlord attorney is, I always try to convince my clients to do a judgment by agreement, because you never know how the case is going to turn out in front of a judge, especially since Philadelphia County tends to be more more tenant friendly. But the other thing is, well, if I got a judgment with a judge, which could be appealable to the Court of Common Pleas, a judgment by agreement is actually a non-appealable judgment. So if I agree as the landlord's attorney with the tenant on a judgment for money and a judgment for possession, and then something happens that the tenant doesn't follow what they're supposed to, eventually I can file a motion with the court saying that they breached that, and then we'll have a short hearing on that, later on. But they can't say, they can't appeal that decision anywhere else. It's that they're essentially screwed. So I highly recommend that landlords always enter into judgments by agreement when they can. If they can enter into a judgment agreement, you can go in front of a judge. And we talked about some of the defenses a tenant would have: an inadequate notice to quit, like a conditional notice to quit. Maybe you didn't give like proper notice. You didn't effectuate the notice the way it was supposed to under the lease, in terms of like you didn't deliver it the right way. Your lease doesn't include a waiver of the rent demand requirement. In terms of security deposits, you're seeking a security deposit as the tenant, can also be a plaintiff. So say like the tenant sues for their security deposit back, right? One of the defenses is that the landlord didn't follow the Landlord Tenant Act of 1951. So with regards to security deposits, the landlord, within 30 days from the time that the tenant vacates from the property, has to give a list of reasons why they're not returning the security deposit, right? So that 30-day period of time begins from the time the tenant actually gives a forwarding address to the landlord, right? So if the tenant never gives a forwarding address, technically the landlord never has to give back the security deposit and or reasons as to why the security deposit should be returned, right? But a lot of times you'll see that the landlord screws this up, where they do have a forwarding address. They don't give reasons as to why they're keeping the security deposit or why they're releasing it. And even if they have legitimate reasons as to why they shouldn't release it, if they don't give that list of reasons to the tenant within that 30-day period of time, they waive their right to keep the security deposit in any manner. So it's really important for the landlord, for multiple reasons, to get a forwarding address, because in case, you have subsequent issues with the tenant, but also, the security deposit is supposed to be held in escrow, right? I don't think the landlord wants to hold that security deposit forever. So if there are valid reasons to withhold money and they want to keep it, let them keep it. And if there aren't valid reasons to keep it, well, then release it, because it's an administrative nightmare to hold a security deposit. So that's one of the things to focus on when you're dealing with these matters. We talked about the breach was not material enough. Again, the tenant could say, okay, you're trying to evict me based on some flimsy breach of the lease. Well, that's not a material breach of the lease. Let's see what else here. The certificate of rental, so the defense that the landlord didn't have a housing inspection license during the time in question that the tenant's technically in default. They didn't have a housing inspection license. They didn't receive a certificate of rental suitability or Partners for Good Housing Handbook. The court will say no right to possession or judgment for possession, and no right to money during the period in time in which the landlord did not have the certificate of rental suitability or the housing inspection license, where the tenant was technically in breach. Let's see what else we got here. And this is all in your materials. And that's basically the ones. Oh, and then the other thing to focus on. So say the tenant actually left the premises early, right? They cut the lease term short in their own minds unilaterally, and the landlord wants to get the unpaid rent for the remainder of the lease term. Well, in Pennsylvania, landlords have the duty to mitigate their damages, which means that they have to show that they've tried to reasonably market the property during the lease term. And if they have, and then they didn't either get the amount of rent that the tenant agreed. So like say this tenant agreed to pay $1,000 a month and the landlord mitigated their damages and it's $950 a month, that $50 difference should be owed during the remainder of the lease term. Or say the landlord couldn't find a tenant, right? A new replacement tenant. Then the landlord's going to be suing for the unpaid rent for the remainder of the lease term. They have a duty to mitigate their damages in the residential context. So they have to show that. They have to show proof of that. And by the way, in the commercial context, there is no duty to mitigate damages. So unless the lease says that you as the landlord have to mitigate your damages, technically the landlord can sit on the property and collect rent from a commercial tenant. Let's see.
Okay, Alan, let me just jump in real quick because I want to get this before the class is over because it is 11:01.
Yeah.
I want to make sure I get the fourth code in. Fourth code is third party. Third party. Okay, one more time, third party. Thank you.
All right, cool. I'm going to try to squeeze in the execution of a lease and an appeal. So say like the tenant loses in front of the judge, right? and a judgment for possession of money are entered, and say it's just a judgment for money, right? And they want to appeal that judgment. They can appeal that judgment to the Court of Common Pleas, right? And, you know, I have the time frames, and you can look at, like, you know, what the time frame to appeal those judgments are, right? It's different from a commercial and residential point of view, but they can appeal it to the Court of Common Pleas. If they want to stay the eviction, they have to provide a supersedious bond, and that's in my materials as well, with the Court of Common Pleas as to, I think, the lesser of 3 months of rent or the amount of the judgment. And then they have to actually escrow the rent going forward while the litigation is going on with the Court of Common Pleas every single month, right? So the good thing is, this is why the landlords would want to file in the municipal court, is that there's a pot of gold at the end of the rainbow when you file in the Philadelphia Municipal Court if the tenant wants to appeal it to the Court of Common Pleas. So if you start at Court of Common Pleas as a landlord, time period's longer, it's a long, drawn-out process, and it could be more complicated. And there is no money like that, you know, at the end when you go to trial, you're going to have to try to collect it and execute against the tenant on that judgment. But when you're starting in the Philadelphia Municipal Court, if the tenant wants to continue from the municipal court to the Court of Common Pleas and they want to stay in the place for whatever reason, there is money to be had under those circumstances. So say the tenant doesn't appeal the judgment, right? It goes to execution, right? So in Philadelphia Municipal Court, it's the landlord tenant officer. And like I stated, they're in my building, 123 South Broad Street, on the 16th floor. The first thing you have to do is file a writ of possession, right? And I'm not talking about executing on the money judgment, right? So you give the writ of possession to the, you know, you get a writ of possession from the municipal court. You take that along with paperwork that you would submit to the landlord tenant officer, and the landlord tenant officer eventually serves the tenant with the writ of possession paperwork, right? You have to wait a certain period of time. Again, it's going to be in my materials, difference between commercial and residential. Eventually, you'll be able to file what's called an alias writ of possession. That alias writ of possession, you'll get it from the Philadelphia Municipal Court. You'll deliver it to the landlord tenant officer. Once you have that writ of possession and you deliver it to the actual landlord tenant officer, they will eventually schedule an eviction, right? Or a lockout. So you'll eventually get a call where it'll say, this is the lockout date, this is the time, please have a locksmith available. And the landlord tenant officer will work with your representative to actually evict, physically remove the tenant from the property. So that's basically it in a nutshell. I'm willing to stay on a little bit longer if need be, if I to take any questions. I apologize for the rush. It's a little different and not as, it's harder on Zoom than if you had people in front of you in the class. So if there's anything else you want to ask me, feel free. If not, Dan's going to get you the materials on some of the stuff that we talked about, the particulars about the time periods to file some of these documents. And then, like Dan said, go on my website. I have so many articles on it about landlord-tenant law. And we do have a COVID-19 resource center which deals with some of these landlord-tenant issues as it relates to COVID-19.
Thank you, Alan. That was great. Do appreciate it.